Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about cruel and unusual punishment. Cases that should have gone to the Supreme Court of Canada, but didn't. In Alberta, the court had to consider whether or not the mandatory minimum penalty for sexual exploitation was cruel and unusual punishment. The Alberta Court of Queen's Bench found that it was, and that the mandatory minimum violated Section 12 of the Charter and struck it down. The higher court, the Alberta Court of Appeal, determined that the mandatory minimum did not violate Section 12 of the Charter, and they looked specifically at what was called the reasonable hypothetical that was advanced in the case. Oftentimes when challenging a mandatory minimum, a reasonable hypothetical in place of the circumstances of the accused needs to be advanced. The question then becomes whether or not the reasonable hypothetical is in fact reasonable. This means that you can imagine a scenario where somebody could end up charged with the offense on the basis of the law as it's written, where the mandatory minimum might not be appropriate. Even though the mandatory minimum might be appropriate for the offender that is currently before the court can find it unconstitutional and either strike it down or refuse to apply it. This was what happened in this case. But the Court of Appeal determined that the reasonable hypothetical that was advanced in the case was not very reasonable at all, and then found that the mandatory minimum was, as a result, not unconstitutional. They imposed a four-year jail sentence. The Supreme Court of Canada has considered a number of mandatory minimum penalties that have been imposed under the previous federal government. Oftentimes in these cases, the Supreme Court of Canada has found that the mandatory minimums violate Section 12 of the Charter because they constitute cruel and unusual punishment. The sexual exploitation provisions have not yet made their way to the Supreme Court of Canada, but there are conflicting judgments from various courts across the country. This is exactly the circumstance that causes a leave application to be granted. If there are conflicting judgments, the Supreme Court of Canada is supposed to step in and resolve them. When it comes to sexual exploitation, one of the most serious offenses in our justice system, with some of the harshest penalties as mandatory minimums for what is potentially the most minor conduct, a simple touch, a simple kiss, that can be something that is absolutely significant and violates Section 12 of the Charter. The Supreme Court of Canada had the opportunity here to resolve the conflicting judgments that have come from various levels of court and various courts throughout this country and determine once and for all whether or not this mandatory minimum violated Section 12 of the Charter. The Supreme Court of Canada seems to have missed the fact that there are conflicting judgments here and that there is an issue that needs to be determined by them on the basis of the very traditional test for whether or not leave to appeal should be granted. This was a classic case in which leave to appeal should have been granted, and unfortunately this means that it's going to take yet another challenge from another province to the mandatory minimum for sexual exploitation before the Supreme Court of Canada may finally realize that it does need to hear this issue. In the meantime, people potentially face lengthy jail terms for offenses for which they should not be sentenced for that long. You're watching Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Brazen Bull Creative has been excellent at putting together these videos. Please like, subscribe, share with your friends, and tune in next week for another episode.